So, my lord, when there are extraneous considerations, your lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue. Issue namely whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my lord, perhaps your lordships may not take a second guess on the basis as to what your lordships would have perhaps perceived the situation to be capable of. I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test, and the only purpose was that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Continuous existence of that trust gives you the legitimacy in democracy. Lord, now this is, 11 is important. Lord, the argument was that floor test could not have been ordered because they, this side and other independents, etc., who withdrew support from the government, they should have gone for no confidence motion. And this is a new point, my lord, which I would be urging for your lordship's consideration, not argued, my lord, so far. First of all, my lord, whether it is a floor test, which is a motion of confidence, or a no confidence motion, my lord, which is negatively worded, the result is the same. And therefore, that can never be a ground to invoke your lordship's equity jurisdiction in a 226. Floor test also, the numbers will be counted and people would decide whether I have the majority. In no confidence, numbers will be counted and members would decide whether I have the majority. But there is something more than that. Lord, please come to PDF page 40 of Convenience Compilation 3C. Lord, the provision in the Maharashtra Legislative Assembly rules regarding no confidence motion. Lord, your lordships are confronted with a situation where the governor is receiving representations that we have withdrawn support, we want to withdraw support, etc., etc. I am not repeating. There is a threat of violence. There is in fact violence. Attacks are taking place at the houses. And now, my lord, the submission is that you should have allowed the no confidence route rather than directing a floor test. Please see, my lord, now page 40 of my lord's Convenience Compilation 3. Your lordships have said, my lord, please bear in mind that such floor test cannot brook any delay. And why is this reliance on no confidence motion? Maybe they wanted more time, which the governor prevented them from doing. Para 90, rule 95. Your lordships have that, rule 95? Yes. Well, two things I'll say at the outset and I'll read this. First, 3C, okay. 3C. First, any member can move a no confidence motion only when House is in session. Not otherwise. House was not in session. Number two, it depends upon the discretion of the speaker whether to allow the motion to be placed or tabled or not. It's not a right. So again, I'll be dependent upon the discretion to be used by the speaker if I am the elected representative. This is what, my lord, therefore governor says that no, you hold a session. Kindly see, my lord, rule 95. A member who desires to move, your lordships have them. The member who desires to move for leave to make a motion expressing want of confidence in the Council of Ministers or a motion disapproving the policy of the Council of Ministers in a particular respect shall give written notice of such motion. If the motion is admitted by the speaker, leave to make the motion may be asked for. So first, he can sit for 1 week to decide whether to permit this or not. But if he admits, then the members will seek leave to make the motion for on such day not later than 2 days after it is admitted. If the assembly is in session, as the speaker may appoint, after questions and before the list of business for the day is entered upon. So when the assembly is in session, this can be done with the speaker. There is no time limit fixed. He can decide to admit it after a week. And thereafter, if the assembly is in session, the members can say 2 days. Now, my lord, further, provided that, the lordship said, my lord, the next page, provided that if the notice of such motion is received when the assembly is not in session, the leave to make the motion may be asked for on a day not later than 2 days after commencement of the session, as the speaker may appoint. So the next session may be after 15 days, after 1 month, after 5 months. We do not know. Your lordships are deciding this constitutional principle that whether the governor was right in directing summoning of the House for floor test, and they are saying that no confidence motion was the route, meaning thereby this threat, allurement, violence, etc., continues, and the governor's satisfaction that prima facie the government has lost confidence would continue without any legitimacy. My lord, borrowing your lordships, very, very, my lord, pertinent expression. After the member has asked for leave of the assembly to make the motion, the speaker shall read the motion to the assembly and request those members who are in favor. That's the procedure, my lord, how the motion would be passed or failed. So, my lord, this is no remedy in fact situation like this. Because the taste, my lord, right from the state of Rajasthan till Shivraj Singh Chauhan is, it cannot brook any delay. Last 3 points. Another option was, my lord, 356, which is frowned upon, and nobody, my lord, that has to be the last resort. And how, my lord, that happened, my lord, please come to, my lord, as a last submission, my lord, the documents which I have placed. My lord, the governor received 2 letters that now Eknath Shinde has the majority. And, my lord, another very risky argument which Mr. Sibal made, that why did the governor call Eknath Shinde to form the governor? And why not the president of the party was consulted? My lord, the governor knows only the elected leader of the house. He is not concerned with political parties. There are political parties where leader of the house is in fact the leader and president is not controlling him from somewhere else. Governor has to contact the elected leader of the legislative party. When he is shown, my lord, I'll show, my lord, those documents. There are 2 letters, my lord, I'll show that document. Because, my lord, every party has a different structure. Kindly see, my lord, the mischief in this argument. I'm saying argument, not mischief in making of the submission. My lord, mischief. I'm sorry, my lord. I thought, my lord, my
they're relieved with your clarification.
No. It was not correctly worded, my lord. The potential mischief if this argument is, my lord, accepted. That's what I wanted to convey. My lord, every party has a different party infrastructure. For example, in some parties, The highest authority is the General Secretary. There is a Politburo in Communist Party. General Secretary is the highest authority. In some, my lord, there is a body, 5 people, my lord, committee or something. In some, there is a president. There may be a dispute who is the president. Governor would not enter into that. Governor would say that who is the leader of the legislative party. Governor would deal with only leader of the legislative party, and Mr. Uddhav Thackeray, who did not face the confidence and therefore he resigned, is not even a member of the Legislative Assembly. My lord, kindly see page 47, PDF 47 of the Governor's compilation. My lord, this is the
PDF page? Sorry.
page 47 of Governor's compilation. My lord. The apprehension of MLAs is also fortified by the letter of leader of opposition, who has in fact provided, kindly further, provided links to videos where Mr. So-and-so has openly stated that dead bodies would come. And I would, my lord, earnestly urge, my lord, not to condone this. My lord, this is a threat in public platform. My lord, let us not, my lord, lessen the gravity of it. It's a very serious thing. I leave it at that. I leave it at that.
Law and order situation.
I leave it. No, my lord. It can be law and order situation also. But if that law and order situation is being created to bring pressure on the legislative process, then it's not just a law and order situation. It is one of the major consideration for the governor that yes, he seems to have lost majority and now open threats are being administered that you come in our fold or you will be sent to post-mortem. My lord, it's a threat to death. I would, my lord, earnestly request your lordships, my lord, that it cannot be taken serious, lightly by the constitution.
That
I leave it
a
at
ground for unseating a government. I mean, ultimately, that somebody who makes that threat is subject to section 156(3), is subject to an FIR. You can do what you want about that.
Allow me to, my lord, put it differently. My lord, that's where the perception differs. If I say that because somebody is threatening, you face the floor test, then your lordships are right. But when I have the letters that we want to withdraw support and we are being threatened, then it's not that reason. That's a ground, not the reason.
We'll hear Mr. Sibal and they have to say in rejoinder, I think.
Yes. Lord, one clarification, not on the merits of the case. I checked up. The couplet, my lord, which I started with.
This was not Barelvi.
It's by Dr. Bashir Badra. They are contemporaries. Oh. Their style of writing is very similar. It's likely to mislead, my lord, every reader. It's by Dr. Bashir Badra. He is no longer there, my lord. Wasim Barelvi Sahib is...
You're giving credit where it is due.
Yes, my lord. Especially when he is not. Dr. Wasim Barelvi is also, my lord, he is alive. Dr. Badra passed away recently. But contemporaries, same age group.
Thank you, Mr.
Obliged to a lot.